implemented fully anywhere in India. Even if it is implemented, it will have a lot of hurdles and difficulties for the psychiatrist, for the patients, for the family. This is the reality. So in this situation, the psychiatrist in India should know about the background of the acts, the sections of the acts, when it is implemented, what are all the difficulties they will face, and how to overcome those difficulties, and what are the pitfalls in which we are likely to be cornered by the law enforcement agencies. Everything we should be very clear, and in such a background, thorough exposure to the act and its implementation and its utilization is necessary for the psychiatrist of India. So I will request Dr. Magesh Gowda to throw more light on the intricacies of admissions and discharge procedures, so that we will be more enlightened by his lecture. Dr. Magesh Gowda, please.
Thank you, chairpersons, for this wonderful introduction to the topic and to the justice that has to be done for the next 45 minutes. Dr. Aleem, I need my slides. If you could put on the slides, please.
Yeah, I have shared it. Are they not coming?
I'm not able to view them, Aleem.
Well, you want he wants control.
Your slide is visible.
I'm not able to see the slides at all.
Can you again do that?
We can see it, Mahesh. It's visible to us.
Yes.
Looks like there's some problem with downloading of entire environment.
Mahesh, you are on the phone or on the laptop?
No, I'm on the laptop now. Should I shift to the phone? Because I think there's an issue. One minute, sir.
You can just log out and log in again, Dr. Magesh.
Yeah, everyone can see the slides?
Yes, we can see the slides.
Okay, then there is a problem with Mahesh.
I think now it's visible. I'll log out.
This is on audio. It is echoing.
Some people are also not seeing the slides that day. But I am able to visualize it.
I'm sharing them again. Are we okay?
Is there anyone who cannot see the slides shared by Dr. Lin? So everyone is seeing the slides.
Any new security features added to the link for today, is it?
No, ma'am.
No. Dr. Mahesh, you can see the slides?
Please unmute Mahesh. Mahesh, can you unmute now?
Yeah, yes. Now I'm able to unmute. I was struggling. I'm able to see my slides now. This is perfect, Dr. Aleem.
Thank you. Go ahead.
Sorry about the technical glitch. I had expressed my difficulties with the net, and I think it's best to be on the phone now. I think over the next 40 minutes or so, we're going to look at major issues that govern admissions and discharge procedures under MHCA. If at all somebody does not read the act, it's all right, but we need to know how we need to admit patients and also discharge them. We also need to know the role of mental health review boards. The third thing we need to know about is the penalties that we would need to face in case there's any violation under the MHCA. Next slide, please. So if you look at what's going to happen, all admissions under MHCA into any mental health establishment will depend basically on one important parameter, whether the patient has capacity to consent for treatment-related decisions. So that is going to govern under which category or which section he's going to fall into. And if you look at any admission that's going to happen under 87, which is for the minor, 89, which is for the involuntary clause, 90 for involuntary and extension clause, the treatment under this section will be primarily taking consent from the NR or the primary caregiver or the family member who's required to be present then. Admission will be done on the request in prescribed forms only. We all got to used to just saying admit patients and things like that. The patient has to come to you with a prescribed form, which is actually gazetted. And with the prescribed form, they also have to give certain information, and with adequate documentation, informed consent, and reasons and justifications for why we are admitting such patients, we'll have to proceed for admission. The MHRB is going to be the backbone for the Mental Health Care Act implementation, and they're going to oversee the admissions of minor, women, and all others whenever there's an extension clause also. And we have to intimate them in specific time limits. Next slide. This is a busy slide. It talks about basically two types of admissions. One is going to be the independent admission, where it's going to be voluntary. It could be an adult or it could be a child. And the next would be supported admission or involuntary admission, where it could be the first section of 89 up to 30 days, the second section beyond the 30 days requirement, which is section 90. So basically, it is talking about who is going to give the consent, whether it's a patient or the nominated representative. In case it's a minor, it's definitely going to be the nominated representative or the legally authorized guardian. And the time limit for intimation of a minor would be 72 hours. And for the woman also would be 72 hours for the MHRB. And if it's an adult male, it's going to be 1 week. So this is a busy slide. Just remember this slide whenever you're going to talk about subsequently on the different methodologies we are going to use for admission clauses. Next slide. So the first section would be section 86. We must remember that this is going to be the most widely used section. That's the voluntary section. And any person who needs to be admitted in the voluntary section, we need to know the section 85, which defines and talks about what an independent patient would be and what an independent admission would be. It refers to all admissions with person with mental illness to the mental health establishment. And here the assumption is the patient has a capacity to make mental health care decision, and we have to prove with an assessment. And he can also make a call on the treatment-related decisions. And in case he needs any help, it would be in the form of only minimal support in making any decisions. Here, whenever we are going to document, it is to a structured, published form on capacity assessment tool that we're going to document the presence of capacity here. We also can make sure we put in certain rules and regulations through bylaws of the mental health establishment by which he is going to be bound to follow during the admission process. Here, the need for admission has to be very clear. He should have a severity of illness which documents and which also is required for the best way of intervention and to get the patient out of the illness. So there should be a severity documented to make sure that he needs admission as the least restrictive form of treatment. And the crux here is if he can get admitted, he will apply to the person in charge of the mental health establishment with the prescribed form. If the medical officer in charge is satisfied with the need for admission, he will authorize admission. But for discharge process, the patient can get himself discharged without actually having the consent of the person who's admitted this person. So this is one crux you must remember. He will admit himself through the procedure, but to get himself discharged, there'll be no actual procedure and binding factors for him. He can get himself discharged on his own. Next slide. So this is the prescribed form that we have to take before the patient gets into admission. They have to go to the counter and make sure the counter has abundant form of forms in all the sections that we are going to use. And he has to fill this up, and then only on the same form, please authorize that admission and say that please admit him under section 86. And then the paperwork should start. Next slide. The next section would be section 87, which talks about admissions of minor, and a minor can be admitted to the mental health establishment only after following the due procedures prescribed in this Act under 87. The nominated representatives of the minor, who will be generally the legally authorized representative or the guardian when it's not mentioned, shall apply to the medical officer in charge of the mental health establishment for admission of the minor The child should have illness that is severe enough to warrant an admission process. There should also be a documentation to say that all community-based alternatives to admissions have failed and has been already tried. The NR or the appointed person will stay with the patient at all times during the admission process. In case he cannot stay, he has to authorize somebody else as his part of representatives to stay with him during all times. The admission should be in the best interest of the client here, and he should benefit from the admission process for recovery. And all admission under 87 are reviewed by the Mental Health Review Board. Next slide. So this is how the form looks like. Most of the form looks similar, except there's small sort of tweaking. They're going to ask about the symptoms of illness. They're going to ask for documentation of previous illnesses, if there's anything. They're also going to ask about proof of authorization as an NR. They also are going to ask for, photo ID proof, phone number, email ID, and things like that, just to make sure the identity of the person consenting is established. This is Form D for admission of a minor. Next slide. Coming to the involuntary admission happens under Section 89. For a person to be admitted under 89, there has to be a clause here which says that there has to be 2 independent evaluations on the day of admission or in the preceding 7 days by one psychiatrist and other one being a mental health professional or a medical practitioner. And both of them independently have evaluated him and conclude that during the examination that admission is necessary under the supported admission clause of 89. And they also have prescribed certain dangerousness criteria to satisfy the need for 89. So here it's very simple. It is harm to himself, but it's been elaborated as has recently threatened, attempted, or threatening or attempting to cause bodily harm to himself. Basically, please remember that it is going to be causing bodily harm to himself. The second clause would be harm to others. So there has to be documentation for has recently behaved, is behaving violently towards another person, or has caused or causing another person a fear of bodily harm. It need not be actually harm. It could be a fear of causing bodily harm. So behaving violently towards other person is the second clause. This 2 clauses most of the patients will have, and it's very easy to document. But if you look at the third clause, it is very tricky here. We must be very, point on here to make sure we document what is needed and to justify the use of third clause. It says here has recently shown or is showing an inability to take care of himself to a degree that places the individual at risk of harm to himself. So it could be like not being compliant with medications. It could be causing a relapse. It could be not sleeping well. It could be abusing drugs of abuse. It could be abusing our own prescription drugs. It could be various other reasons that could put him at a risk of harm to himself. So this is a very important clause. We must use this clause to the best of our needs here and make sure we document the rationale why we are actually using this clause and make sure we are very clearly giving information on the patient's inability to take care of himself that is putting him at a risk of harming himself in some way. Next slide. So the psychiatrist and MHP, after taking account the advance directive in case if he's made anything, should certify that the admission to the mental health establishment could be the best possible option and the least restrictive care option available to make sure he gets his treatment to get well. There should also be a demonstration to say that this is a loss of capacity and he needs high support care. And the capacity assessment should be repeated every 7 days during the first 30 days of admission under 89. The treatment will be given only in accordance to the AD if it is provided to you. And in case if the AD is not provided to you, it should be a treatment plan which is discussed, and it should be a shared decision-making model where the NR and the doctor and the treatment team are a part of the decision-making process. A person with mental illness admitted under this section, if discharged before the 30 days is lapsed, can get readmitted again, but not under the same clause if he's getting admitted within the 7 days period. So if it's after the 7 days period, you can actually again use section 89. But if it is within 7 days after discharge, we have to use the next section of section 90 here. Next slide. So the admission here, when we use the section 89, is going to last up to 30 days as the maximum that's been prescribed here. On the expiry of 30 days, we will have 2 options. One is, in case we are able to demonstrate that he has still the dangerous criteria, he needs to be continued in the mental establishment under the involuntary clause or the sectioning that's needed. We'll have to use section 90 here. Suppose the dangerousness criteria is not met and we are not able to discharge a patient and he still needs continuity of care, we have to move into section 86 here. So these are the only two options that we have. Either we say that patient is all right and recovered enough to become a section 86, or he's not recovered enough, he still has dangerousness criteria that's been met and he has to be moved to section 90. Next slide. The medical officer and the mental health professional in charge of the establishment shall report to the concerned board on all the admissions that happens under the sectioning process. It is within the first 3 days for the woman and the minor. It is within the 7 days for other than the woman and the minor here. It could be the adult males. And board reviews admission within 7 days only if there's a request for review. If you look at the process here, why MHCA has prescribed MHRB to review admissions, you need an appeal process. If the doctor and the NR decide to admit the person into the mental health establishment and he needs to appeal, there has to be an appeal process. So mental health review board has to intervene and review our admissions and approve our admissions. So under this section, there's going to be multiple admissions that's going to happen across the country. And just to prevent this sort of overload of reviewing process, they've kept this clause of reviewing only if there's a request. Request for review can come from the patient, from the NR or an NGO here. And once the request comes, the board is going to review the need for using the section 89 and they're going to approve section 89 or ask the patient to be discharged. And they have a time frame that's prescribed, that is 7 days. Next slide. So this is the form that is being published for the application with high support needs. It's Form E. So basically most requirements that they're asking is similar. And only the context of the admission is changed. So that's why the form is 80% similar in most instances. But please use the prescribed forms only when you're asking them for admissions. Next slide. So the extension arm of sectioning would be section 90. If a person with mental illness admitted on section 89 requires continued admission and treatment beyond a 30 days period, or the person with mental illness is discharged and he requires readmission within the subsequent 7 days after discharge, he shall be admitted in accordance to clause that is prescribed under section 90. The medical officer or the mental health professional in charge of the mental health establishment shall report all admissions and readmission under this clause within a period of 7 days for the admission and readmissions to be reviewed by the concerned board. Next slide. So here the requirement is very clear. Earlier it was one psychiatrist and one mental health professional / registered medical practitioner. Here admission has to be after 2 certifications from 2 psychiatrists, and both psychiatrists should independently evaluate him within the preceding 7 days and conclude that continuation of admission is absolutely essential here. And the criteria for dangerousness is slightly tweaked here. Though the clauses are similar, bodily harm to himself, behaved violently towards another person is also there as a second clause. Inability to take care of himself that puts him at the risk of harm to himself is also there as a third clause. But what is different here is it says that he has consistently over a period of time shown all this sort of behavior, because our observation period is 30 days. And in the 30 days, we are able to demonstrate that he's consistently had all this sort of problem. This dangerousness criteria has been met here, and so the patient can be admitted under section 90. Next slide. So the board, after receiving such intimations from the mental establishment, within a period of 21 days from the date of intimation, will have to approve this admission. If they don't approve, they'll have to state the reasons and also ask the patient to be discharged also. In all cases, the application of readmission or continuation admission, the board may require the medical officer and the psychiatrist to have a plan for community-based treatment also. We've done a lot of work under section 89 to take care of the patient and stabilize him. So during this period, the review board expects us to come up with a community-based treatment plan subsequent to treatment and getting better, on demonstrating the progress that is being made and are likely to be made. we'll have to make sure we demonstrate a plan that we have towards treating this patient in the community also. Only on satisfaction of this sort of community plan, the patient could be getting an approval under Section 90 for a continuation of care under involuntary clauses. The person shall not be permitted to continue in the mental health establishment in which he has been admitted for other than the dangerousness criteria reasons and inadequate symptom control. It should not be used merely on the grounds that there's non-existence of community-based services at the place where the person ordinarily resides. So non-existence of community-based rehabilitation centers or not having a home of his own or not having a family member to take care may not be the grounds for continuing the person on Section 90. Invariably, if you look at most centers, we are all stuck with this clause here. Patients are recovered, but they're not recovered enough to actually be moved out of the mental health establishment. We don't have available options of community services in the nearby vicinity to the patient, and hence there we will have trouble to discharge this patient. All of them have to be moved to Section 86. The patient has to be intimated that he is no more under the involuntary clause. When he says that it's 86, he has a right to move out of the establishment at any point that he decides to move out. So this becomes a difficulty here. And that's why most mental health establishment, if you were to do the audit, we're going to have this sort of difficulty. There's going to be a huge chunk of patients who are in this sort of criteria where they are recovered enough, not recovered enough well to be discharged to the community. Next slide. The admission in this clause of Section 90 will last up to 90 days in the first instance. Subsequently, if you are able to demonstrate that there's a need to continue this patient in the same involuntary section, the subsequent approval will be for 120 days. Subsequent to that, if you're able to still demonstrate there's a need for continuity of care, it can be 180 days on each subsequent approvals. So capacity assessment under Section 90 has to be done every 15 days. And please remember that as soon as the patient becomes capacitous, as soon as the patient does not have any of the dangerous criteria that we had mentioned, A, B, C, patient cannot be continued under involuntary clause. Whenever the patient becomes capacitous and whenever there's no such symptom that we can demonstrate, he has to be moved to Section 86 clause. Next slide. This is the form for application for continuous admission with high support needs. It's Form F. It is a little more briefer. It just says that we need to continue and they're making a request for us. Next slide. I also brought in the concept of Section 94 here, though it's not an admission clause here, but it's a treatment clause here. This is a very wonderful provision that the Act has envisioned simply because a patient needs treatment in community, patient needs treatment at the grassroots level where psychiatrists may not be available because of the deficits in trained manpower. So any medical practitioner can initiate any treatment other than medical treatment. He can also initiate treatment for mental illness in the community or in a registered setup. And it has to be demonstrated that the need for intervention is to prevent death or reversible harm to the patient in crisis. If the person is inflicting serious harm to himself or to the others, or he could be causing damage to property. Again, this is dangerousness criteria here. The only thing that's an addition here is they've actually added destruction of property here as an additional clause here. So if you are able to demonstrate that the patient is at risk of harming himself, others, and destroying property here, there's a provision for us to intervene and treat him at the community or in any other health establishment by a registered medical practitioner here. This emergency treatment clause can also be used for transporting patients from the community into an establishment. Earlier, we did not have these sort of provisions here. Now there's a legal provision to use this Section 94 emergency clause for transporting, mobilizing the patient in crisis from community into an establishment. Next slide. So it gives a lot of freedom here, but there's also restriction here that comes with the Section 94 emergency clauses. We cannot use ECT because the moment you know ECT, it's more a specified form of treatment. It is a psychiatrist's opinion. And this sort of interventions can be done only after a person can be established as a person with a crisis. He needs this sort of ECT in a mental establishment after evaluations by a psychiatrist. So this sort of evaluation, once it's complete, this section no longer holds good. So ECT cannot be used in Section 94 emergency clause. This section is limited to 72 hours just to make sure they have 3 days window to move him from the community into a registered mental health establishment. And the moment the assessment is complete or the moment the patient reaches the mental health establishment, this section 94 ceases to exist. If it is 72 hours or the moment he reaches the mental health establishment, whichever is earlier, the section 94 can actually cease to work once either one of it is satisfied. Next slide. I've also brought in the concept of section 100 here, though it's not directly related to admission process here. In the responsibilities given to other agencies, the police is a very important part of intervention here that actually people can take help for. So the duties of police officers in respect to persons with mental illness has been specified here. He has some responsibilities for people whom he finds who are wandering at large and whom he can believe that he is a person with mental illness and he's incapable of taking care of himself. So such people who are wandering person with mental illness, he has a responsibility to take into custody and actually produce him to the nearest public mental health establishment. Suppose it's not a person who is wandering, it could be any person at home. If the police officer believes that the person within his police station limits, the person is at risk of harming himself or harming others, and he has a reason to believe that it is a product of the mental illness, he can pick up this sort of person from the community and produce it to the nearest public mental health establishment. He is allowed only 24 hours time limit to keep in the police station. He cannot be detained and kept locked up. The person has to be intimated why he's been brought to the police station and under what section he's been brought in. And the process has to be explained before shifting to the nearest public mental health establishment. Next slide. In case a person is wandering and he does not have a home and is a homeless person, there's a first information report that has to be lodged, and it is the duty of the police to trace the family and help him reach his family, even though at that point of time we have no whereabouts, but it's his duty to register FIR so that investigation can proceed from that. Next slide. Next slide, please. Yes, thank you. So the next section that's relevant here is we can take help from the police. We can also take help from the magistrate here. When a person with mental illness appears before a magistrate or is brought by a family member or by a police officer before the magistrate, he can do two things. One thing he can order is to transfer this person to the nearest public mental health establishment for evaluation. So conveyance is one thing he can talk about. Next thing is he can authorize admission for observation, evaluation, and assessment for a period up to 10 days. So the magistrate can make these sort of orders. Suppose the family needs help, they can also go to the police, they can also go to magistrate. It's good that they created this sort of multiple steps and help that they can take from the community and from the judiciary to make sure the person with mental illness gets the required due. Next slide. Section 103 also talks about admission, but it's under special provision. It's according to the Armies Act, the Prisoners Act, the Navy's Act, the Air Force Act. All these acts are special acts where a person, if he's under care in a prison and he needs to be moved into a public mental health establishment because all prisons don't have services for mental illnesses. So he can be moved in Section 103. Next slide. If at all there are provisions for a psychiatric ward in the establishment, you cannot use this clause. Only when there's an absence of a psychiatric ward, they can use this sort of provisions under 103. And the medical officer in charge of the mental health establishment in the public sector needs to inform the authorizing person every 6 months on the update of each person that's been referred here. Thank you. Next slide. Coming to certain special provisions and looking at what happens if a woman is admitted, there is right to equality and non-discrimination under Section 21. That basically means that if a person who's a woman who's admitted and she has a child less than 3 years of age, we have a duty not to separate them unless and until we're able to demonstrate that there's a risk of harm to the child by the woman who's having mental illness. And in the best interest and safety of the child, we are asking for this sort of temporary separation. Even during this period of temporary separation, the woman will have access to see the child under supervision of the staff and the family member, and we cannot totally cut off her rights. This decision to separate the child has to be reviewed every 15 days, and if it exceeds 30 days, we need approval of the board. That's the authority. It could be mental health review board. If they're not existing, it could be state mental authority. So the woman who has a child less than 3 years cannot be separated unless and until we have documented evidence for dangerousness to the child criteria. Next slide. Coming to transfer of persons with mental illness, we have section 21 again, right to equality and non-discrimination. So they should be able to avail and use the 108 ambulance services like any other person with medical illnesses. We also have section 104, which is very well thought of. We have a lot of persons with mental illness residing in beggars colony, a lot of orphanages, a lot of state-run homes are there where all of these people with mental illness are there. So it is the duty of the officer in charge of this sort of establishment to identify people with mental illness and move them out of the custodial centers into a mental health establishment. So section 104 can be again used for transfer of persons with mental illness from state-run custodial homes. So in case he needs to be treated, it will be according to treatment under section 87, 89 or 90. If he is voluntary, it would be section 86. Suppose a person is under treatment in a mental health establishment and for reasons that could be found during audit that he's violated a person's rights or they've actually not followed the minimum norms criteria, the board can actually authorize such persons to be removed from mental health establishment and admit under some other mental health establishment within the same state or some other state after taking permission from the Central Mental Health Authority to make sure the Central Authority coordinates the transfer across the states. Next slide. Coming to discharges, so before we actually think of discharge, we have a wonderful option here, section 91, which talks about leave of absence. So we can actually use this clause to the duration that you think is suitable. It could be X number of days with prescribed rules and regulation that you think is needed, and also make sure the patient signs up a contract, and you can permit him to leave from the hospital and go and come back and report back to you with the feedback and follow-up of what exactly happened during the leave of absence. And any patient who needs to be discharged, the discharge planning becomes a very important process here. And immediately after the person is admitted and during the period of admission and inpatient stay, throughout there has to be an updated admission to discharge planning process. And you should have a sufficient discharge planning to address the practical and social reasons that would influence the admission, and also to look at the safety and welfare of this person in the community. So another important section I would like to, just one slide back, please. Another important section I would like to emphasize here is again right to community living. Here under section 19, it very clearly says that every person with mental illness shall not continue to remain in a mental health establishment merely because it does not have he does not have a family, or is not accepted by his family, or is homeless, or due to lack of absence of community-based facilities. So it is his right to live in the community, and most patients who are in mental establishment, because of this reason, it becomes relevant that we actually work towards addressing these sort of concerns. It's the duty of the government to provide this sort of facility, but till such facilities have been provided and infrastructure is upgraded, we are still in a gray area. We really don't know what to do with these sort of patients who are ready to be discharged and still don't have a place to go. Next slide. So this is the application for leave of absence, section 91. Next slide. So section 88 talks about discharge process. If he's another important thing is here, if you admit a person under section 87 and he was a minor and he turns out to be 18 years during the admission process, he has to be moved into section 86. And all discharges happen during 86 or 87 under the section 89 criteria. Basically, it's for voluntary admissions. And in case you get a request for discharge under the voluntary admission criteria, you have 24 hours window to decide whether you want to retain him for some more time for evaluation assessment. If you have reasons to believe that he has dangerous criteria and he has inability to take care of himself criteria, if you don't have anything to support your contention, and if you don't have documentation to support this sort of say of dangerous criteria, he has to be discharged immediately after the 24 hours lapse. So you only have 24 hours window to hold him for further evaluation assessment. Otherwise, as soon as the patient gives application for discharge, you have to discharge him within 24 hours. Suppose the next slide. Next slide, please. So this is application for discharge by the independent patient. So there may be a lot of situations where the patient wants discharge and you don't agree, and you don't see that it's in the best interest of patient. But if the patient is capacitous, if he's under section 86, we only have 24 hours window, nothing more than that. We have to discharge this patient. If you don't discharge, he can discharge himself without completing any of the discharge formalities that has been prescribed by the This is application for discharge by minors, and this application is by the nominated representative. So he talks about his declaration as the nominated representative and also talks about document evidences again here. Next slide. Section 98. So discharge planning, a huge onus is put on the treating psychiatrist about the management of this patient in the community subsequent to discharge. So the patient may be getting discharged into the community, or he could be moved to a different mental health establishment under the care of a different psychiatrist. So it is our responsibility to make sure we make a plan which is conducive for his recovery in the community. We discuss with the person with mental illness. We talk to his NR. We also talk to his family member and related people who are involved in his care and upbringing. And we also have to talk to them and find out with whom the person is going to reside after discharge from the hospital, and also identify psychiatrists nearby in case he needs any psychiatrist to be identified there. And after having taken all such inputs, we have to make a plan that is conducive for his recovery. Next slide. Plan developed as to how the treatment and services shall be provided to the person with mental illness in the community becomes relevant here. You should have a lot of detailing about the requirement for monitoring, requirement for follow-ups, requirement for adherence to treatment, and anything that you think is important for his maintenance of recovery has to be covered there. The discharge planning under this criteria, actually, section applies to all the discharges from the mental health establishment, be it 86, 87, 89, or 90. So everybody needs to have a discharge planning before we actually discharge this patient. Next slide. I also thought an important point here would be about the audits here. We are definitely going to be under audits from the external agencies and our own internal audits also. So every 3 hours we'll be audited for all the admission, discharge, minimum norms criteria. So anything that is a lacunae here can be pulled up. They're also going to look at violation of rights that has been done by us. In case we are penalized for any of the violations, and if we are convicted of an offense, if you violate the rights of patients, if you don't maintain minimum standards criteria, the authority can cancel the registration under the act here. Please remember that audits are there every 3 years. They're going to charge a fee which is being prescribed, and we have to make sure we comply with all the audit requirements. Next slide. We also need to have a lot of self-audits because we have so much of documentary procedures and so much of change in the way we admit and treat patients, and also documents the intake of these patients and the informed consent process. We need to do audits on our own, maybe every week, every 15 days, just to make sure we are looking at every admission, looking at admission forms, looking at 2 certifications that's needed. Do we have the physical certificate in place? Looking at the status of admission, is he 86, 89, 90? Is there a time frame that we have to follow up and make sure he move into the different classes here? Is capacity assessment happening on every occasion on the prescribed time limit of 7 days or 15 days, as the case may be? Then we should also have restraint forms and documentation for the rationale cross-signed by psychiatrists. And every month we have to send this form to the Mental Health Review Board. We also have to keep updating our discharge planning, which is very client specific. So each patient needs to have a separate page on discharge planning, and we have to keep updating our plans on that page. I also thought I'll talk on leave of absence of psychiatrists. I would have admitted this patient. I need to go on a holiday for 7 days. In my absence, I have to identify somebody who is going to be responsible as the treating psychiatrist here, and I should have a leave letter in place to say that, and somebody else should take over my admission. There should be a documentation, and these are requirements that's going to come in. Consumer forum can be harsh. NMC has prescribed guidelines for all these things. Even for leave of absence for psychiatrists, I think there's a procedure we must all follow and make sure we are compliant. Next slide. Lot of newer documentary procedures, lot of forms here. These are endless. We've also written a chapter on newer documentary procedures under the Mental Health Care Act supplement that we did. Next slide. We have difficult scenarios here. We've admitted patient under 86 and he leaves the establishment without completing discharge formalities. We also have people under the section 89 clause who are admitted and they could leave the premises without completing discharge formalities here. We have not done discharge planning, we have not authorized discharge, but still they can absent themselves. This could be unauthorized leave from the mental health establishment. These are difficult issues. But the Act is silent on all these provisions here. There's no responsibility that's been put on us for Section 86, Section 89 or 90 patients. Only if the patient is under 103 section, that is, if he's a prisoner, if he's under trial, if he's been under some penalty, and if he's serving a sentence, if they are admitted under the MHCA provisions under Section 103 referrals, then only we have an obligation to inform the police and register FIR for tracing this patient back. Otherwise, there's no specified obligation that has been put on us under Section 86, 89 or 90. We also have special population like pregnant women, newborns, postpartum psychosis, geriatric population, and the child population here. So there is a requirement in the Act which says that we have to make the environment conducive for a newborn, for a child, for a geriatric person, to make sure the recovery is optimal, and we don't mix them with the general population is what has been there, and we need separate wards for them. We also have admission to rehabilitation centers, de-addiction centers, halfway home, hostels, sheltered workshop, daycare centers, home again model. So there are multiple places where admission and discharge processes happen. And we are regulated, we are supervised, and we are actually overseen by the Mental Health Review Board. Suppose there's no admission process, the patient stays on his own in a home again model, and we are not under the direct supervision of a professional caregiver, or there's no assessment, there's no intervention that's happening in the center there. They don't need registration and they don't need to be regulated and monitored. Daycare center, they're not residential care centers, so they need not be monitored again. Sheltered workshop, it's not a residential workshop. Again, they need to be monitored. Only place of residential cares needs to be monitored under the mental health review boards and the licensing system or registration system. Next slide. Next slide, yeah. So I thought I'll spend another minute on talking about how to mobilize a patient with mental illness in the community. So firstly, we could ask one of the first degree family members to come and discuss with the psychiatrist, give a detailed history. There has to be documentation, there has to be a declaration from them on the need for a mental health evaluation or admission process. Once we have established this, we could also look at the past history of mental illness, documentation for that, and also build up this sort of file system. Then subsequently, the patient and the family member can have three options here. The family can convince the patient to meet the doctor for a health checkup if that is still an option available. We have to still exhaust this sort of option. If the patient is aggressive and uncooperative, they can reach out to the police under Section 100B, which enables the police to do this and help them out and take them to the nearest public mental health establishment. They could also make an application to the magistrate 102(1)(a) for conveyance and 102(1)(b) for authorizing admission up to 10 days. So these are the options that they can exhaust before trying anything else. Next slide. When all the above options are explored and it's found not executable, we can actually reach out for ambulance service coordinated by mental health establishment, and the person with mental illness could be picked up with upholding of his rights at all times. We need trained manpower personnel like psychiatric nursing assistants, psychiatric support workers, security. You can have a doctor to visit. You can have your own protocols to make sure the treatment is more professional here. Informing the nearby police station, taking approvals, taking acknowledgement from them also could be a good practice here. And sometimes there could be legal untoward complications that may arise, and keeping the police in the loop is important. Police may be helpful. Sometimes they may refuse to help. At least trying to make our attempts is definitely going to take a way forward in case there's a complication that may arise. It will help the family and us also sometimes if something goes wrong. Next slide. Some do's and don'ts. I think all of us have got used to taking signature for consenting process. So the court no longer looks at the consenting as just signature. It is a process in which a lot of discussions happen, a lot of documentation has to happen. We have to provide a lot of psychoeducation about the illness, and also the mental health care related provisions like AD, NR is our obligations now. One should also stress about the risks and benefits equally, and we should not just overly emphasize on benefits alone. We have to make sure we document and explain to them. Documenting the patient's capacity to participate in his or own care is very important here. If he's incapacitous, it has to be via a documentation only. And there should be uniformity that is maintained in all the medical records, because in a patient record, we have a doctor seeing, we have a RMP seeing, we have a psychiatrist seeing, we have a social worker seeing, we have a psychiatric nurse seeing, and the multiple people seeing. I think all of us have to be on the same page in terms of documenting the patient's assessment and progress. The quality, content, needless to say, they have to be accurate. The rights of persons with mental illness and provision under MHCA 2017 have to be followed at all times, and they have to be made sure that we provide whatever is conducive in the mental health establishment. We can have our rules and regulations and prescribe our own expectations during the admission process, but they cannot be against the provisions of the rights of persons with mental illness provided under MHCA 2017. We also have to display the details of the Mental Health Review Board, the local legal service authority who can provide free legal aid at the time of admission itself. They must know that they can consult review boards. They must know that they must take, they could take help from the legal aid in case there's any need for contesting admissions. We have to follow the advance directive at all times whenever it's provided to us. And the discussions with the nominated representative in involving the patient's care process is also very important. And NR generally consents for 87, 89, and 90. So make sure we keep all of them in the loop and it becomes a shared decision-making model. Next slide. I think I've just briefly touched about the intricacies of the admission process. I'm seeing a lot of chat board, which is full of so many questions and also comments on so many provisions of the Act. I think it's over to the moderator to facilitate this sort of discussion. Thank you very much.
Thank you so much, Mahesh, for an elaborate and lucid presentation. I think despite discussing it too many times, we are still wiser from your presentation. Thank you so much. Over to chairpersons for their opening remarks.
I think they must be unmuted.
Yeah, we can, all our co-hosts, they can.
Okay. If I may take the opportunity of saying a few words, I think Mahesh, very extensive presentation. It's not easy to summarize and to give a bird's eye view and overview of such detailed admission discharge procedures. But a few things which have caught, catches the attention of us as psychiatrists, as doctors, physicians who deal with mentally ill patients all the time, and how MHCA is presenting the kind of entire issue of admission discharges to us. One, and which is very, I think if we read in between the lines and read the fine print, that section 85 says that most admissions should be voluntary as much as possible, considered voluntary as much as possible, and only when an involuntary admission becomes unavoidable, we should go for involuntary admission. Otherwise, in most cases, instances, it should be voluntary. So that is something which should give us some kind of a freedom and opportunity to at least see that most patients would fall under that category. That is one. And also it says that the most patients, they will have kind of the capacity to be able to talk about their own admission. And most patients who have capacity and can take treatment decisions for themselves or on their own or with minimal help or support from others, the family or other people. So even that is provided. It's not that the patient individually himself should have capacity in toto, but even if, he needs some help in deciding about his treatment and admission with assistance and help from others, even that will be included in voluntary or unsupported admission. That is something which I think is very, very important. And the other thing which is impressive is that with regard to admission clauses under 86, 80, 89, 90, all clauses, the role of family member or caregiver, the word is not mentioned. If at all, it's NR that is mentioned. The family member caregiver is not mentioned. The name of family members or caregivers comes only when they are discussing about discharge planning, section 98. That at the time of discharge planning, that the planning is to be kind of discussed or made together in consultation with the NR and the family members, caregivers, or with whom the patient is going to live after discharge and so on and so forth. So that is, I feel, is little ironical that the patient's admission is the family and caregiver have no role in admission, but they have a role in discharge planning. Whereas I think in admission also there should have been a role for themselves. And other thing is that what Mahesh has also emphasized with regard to section 89 admissions criterion 3, when the person is unable to take care of himself to the extent that it poses harm to self. Now, a person who is not able to take care of himself to the extent that he can pose harm to self can come under several scenarios, and it is not very clear. I mean, it's something like, for example, the patient straight away can harm to himself means a suicidal attempt, homicidal attempt. Apart from that, or destruction of property. Apart from that, patients who are non-compliant with medications, patients who are abusing substances, patients who are also indulging in some kind of a behavior which is not conducive to his health. So here, harm, the word harm is not defined as to what kind of a harm to self will it include, and we don't know what all scenarios can be included under this category. That will be a kind of a question. I think these are some of the comments that I thought they were little they were not in the regular. I mean, these are the kind of reading between the lines and not just the kind of written word that has been there in the act has already been presented by Mahesh, but then these are a few other comments on which there is silence. MHCA is silent. I thought I will highlight, and that's it. And Dr. Malayo, please.
Thank you, Dr. Magesh, for your very precise lecture on the admission procedures and discharge procedures in the Mental Health Care Act 2017. I would say in the last 5 years or so, how many patients have been admitted under Section 89 or how many patients have been admitted under Section 90? That will be a very, what to say, very few. In all over India, if you take the data of how many have been admitted under Section 89 or Section 90, we don't have data first. And as far as our knowledge goes, it will be very few. That means we are having the act in the paper. We are not having the act in the field. Maybe many reasons. These will be lack of full understanding about the act by even the mental health professionals, the bureaucrats. All these things will come under the intricacies of admission procedures and discharge procedures, I would say. So I think it should be open to the audience to have discussion and to discuss on those issues. What are the difficulties we have? What are the difficulties the patients have, the family has, to open up on the intricacies of admission and discharge procedures. I think over to the moderators, please.
Thank you so much, sir. Amrit, Kumawat sir is there. I think we can get his comments.
Well, first of all, a very sorted out presentation on the intricacies of admission and discharges. I would like to say that as long as these boards, which are not functioning to its full capacity in many of the states, we need to be honest with what we are supposed to do as far as the records are concerned, documentation rather. But what I have seen, even in metro cities, just 2 days before I visited one hospital, mental hospital, and I was there for almost 7-8 hours with the director of the health services of the state. The in charge of the hospital even did not know that a 13-year child first where to put him in, what are the criteria when you admit such person or child, and what further needs to be done once the child is admitted. And at the end of the day, he has the guts to tell that the child was mentally retarded. So this is a blatant violation which is happening from the government platform itself, or it's the lacunae of knowledge from the chief of the mental hospital, government mental hospital. So this is the scenario, this is the ground level scenario in a metro city mental hospital. And secondly, about the section which involves police. The reply that comes from the police on the face of the caregivers or the any good people who are supporting the social activists is ये हमारा काम नहीं है. Despite being told about this section, nowadays I've started forwarding this section to them. Or at times we tell them this section and they arrogantly say that हमको मालूम है, we will do our job. And then once you put down the phone, they will send them away, will tell them that you take it, it's your responsibility. So unfortunately, this is the ground level situation, though we are doing this exercise so seriously. And if this is going to be, there are certain sections which involves non-mental health professionals to implement this act, then it's a really serious challenge posed to us that whether you, despite offering a liaison to teach them or sensitize them about mental health and legislation related to it, they are not coming forward to understand the same. That's it. Thank you.
Thank you, sir. Thank you so much for your comment.
Ali, may I just add here a few things here? About we following the Mental Health Care Act, even though we don't have a review system, in the last 4 years plus, I've been just following as though somebody's going to come and inspect me, and all admissions are categorized in the same way. In the administrative billing process, in the paperwork that we are doing, we are exactly doing what is need to be done under MHCA. It's a good practice to evolve and make sure we become compliant that way. Otherwise, the penalties are so severe, it becomes difficult to handle. And we are doing a lot of clinical work, but additional paperwork and tremendous sort of pressure that comes in with this sort of expectations is a huge thing. But we must change and make sure there's a shift in the process of documentation here. I think it's definitely going to be fruitful if we all adapt and make sure we follow this act to the spirit of the legislation. Even though we are not scrutinized, please think that the review board is going to come and see you tomorrow.
Even if there is no review board.
Yes.
That's it.
You have to work in some, because one bad case can pull up and actually make me wind up my practice. It can be so devastating. The eyes of the media, the eyes of NGOs are all actually going to easily scapegoat a psychiatrist very easily and say that he has not followed the provision. So in our state, we have the review board that's active. He's constantly seeking information. He's not doing anything, but he's seeking information on 89, 86 admissions and 90 admissions, and he's not approving, but he's collecting all the data from us. The last 3 months, we've been providing data to him. We don't know, every time I'm getting circulars, which are all threatening circulars. If I don't comply, these are the sort of penalties that you have, is what he sends to us. So he's already started working with our state.
Just a question. Can I interfere? Dr. Mahesh, where there is no review board, right?
Yes,
where
sir.
you will report the admissions?
Sir, what we had to do is do all the paperwork that is similar. In our hospital, we had made our own medical board, sir. Medical board can have at least 3 or 4 people to just look at it independently and to make sure that we are following the law. In NIMHANS also, they had constituted an internal board for review.
That is separate, but where it is written that board will substitute the mental health review.
It's not a substitution, sir. It's just to follow a procedure, just to make sure we are regulated. We are trying to self-regulate ourselves. Review board will come and he's going to regulate us eventually. But till that happens, it's good to follow something and gear our practice to suit the requirements that is expected from MHCA. It's a huge requirement and a lot of changes, sir. So it won't come in a day's time. It will take years' time to adapt to our practice. We've been trained in our training programs to do a lot of documentation, which becomes irrelevant in the current mental health care scenario. It just says collect basic medical information that is needed. For IP, it is so much. For OP, it's so much. All other relevant history becomes irrelevant for the law here, sir. So we have to reorient ourselves in terms of training that we've had and also our documentation and the way we see our clients.
Can I ask a question to Mahesh? How many patients, what proportion of patients are under 89 and what proportion under 86?
Ma'am, what we are doing is anybody who actually is not consenting for treatment and the capacity assessment says he's not capacitous, we are like a referral center. Most of them are violent. They would hit somebody and come. So they all fall into section 89. Every day, we are at least reporting 2 to 3 section 89 cases to the board, ma'am. And if we are able to stabilize the patient within 30 days, we are not moving them to section 90. We're moving them to section 86 and saying that they are liberty to take them whenever they want. We are also using the discharge planning criteria there and saying that I have to identify a constant caregiver. I have to identify a suitable place for him to go and live there. So if patient cannot go, if he does not have a place to go back, if the family disowns him, my discharge planning cannot be complete, ma'am. So we are working on all these areas to see how we could use this time to stabilize this patient and also be in compliance with the law, ma'am. So most of them get into 86 after 89. I'm just thinking, I don't know the feelers of the review board because this review board can permit me section 90 or he may overrule and say discharge the patient. We never know. He's a very strict person. So I've not ventured into moving them to 90, ma'am. I've just kept them on 89 and move them to 86, ma'am. So every day I'm reporting 2 to 3 admissions, ma'am.
Section 89 will be the commonest admission in our setup.
Yes, sir.
That is obvious. But the whole thing, if this is a law by the government and it is responsibility of the government to establish review boards, I can quote 1 or 2 cases where the government, the sitting judge did not take cognizance of these things because they think that this such body is a biased body, found by my medical college, found by my institution. Whatever it may be demands, it may be aims, does not matter. It is biased body to protect me. And sometime because of some other motive, there is the sitting judge takes a adverse opinion. None of this thing. Therefore, we have to compel upon government to see that the review boards come up. That is essential because everyone is willing. Discharge planning on everyone can do. It needs some pieces of paper and some commitment. But MHRB and will discuss that has to come up by the effort of the government. And just as there has been a lot of penalties for this, treating doctors and the mental health establishments, what is the penalty for the police officers and others who do not comply to the need of the time?
In fact, a lot of government babus, including the review board, have anything done in good faith clause to protect themselves, sir. They actually easily get away, sir. Only psychiatrists, treating professionals don't have a good faith clause.
Yes, that is why we cannot take use of Dr. Kumawat told. I have been working with lunatics for so many years. Previously, it was easy. Nowadays, it's difficult. You send them the class, they are more silent. The police officer remaining silent, you cannot do anything.
There are many questions in the chat box.
Many questions. Many questions.
Questions in the chat box, I think.
We'll take it fast.
Yes,
Yeah.
Amrit.
Yes.
So we'll take as it comes. What section should be applicable when a patient discharged from section 89 in one MHC seeks admission in another MHC within 1 week of discharge?
It becomes section 90, sir, because if it's within 1 week, we cannot use 89 again, is what is very clearly mentioned. Outside the 7 days window, you can use 89 again. Otherwise, it becomes section 90.
Even if it's another center?
Yes. Because it's the same law. It's the same law. We've exhausted the provisions of law of this 30 days.
It's presumed to be the extended or continued
Okay.
admission. If it's, that is
Of the previous admission.
Yeah.
Yeah.
Another interesting question. I faced it. That's what I would take the question. I'll give it to Alim.
Or it can,
Wha-
sir,
wha-
or
what
it
shall-
can be 86, or it can be 86.
Okay.
Can be,
What-
it should be either 90 or it can be 86. It cannot
Yes.
be 89.
What shall be done if a patient under section 86 refuses discharge even if he is fit for discharge?
Sir, we have one option here where we have a code of conduct or something like rules and regulations of the institution. At the admission criteria itself, they say that the psychiatrist or the professional in charge of the mental health establishment should be satisfied that he is going to benefit from the admission process. So we have a level of control in controlling the admission there itself. Suppose you're not satisfied, you can refuse admission there. He'll make a request, he's making an application, you can refuse the admission itself. Suppose he's already fit enough for discharge. If there's a government hospital, if it's a public mental establishment, it will have a huge financial implication because most of them will say that I'm not fit enough for discharge. They can feign illness. They can say they have auditory hallucination. They can say a lot of things and continue to utilize the resources of the public mental health establishment, actually exhaust a lot of resources and occupy the beds. This can be a huge problem that I foresee because it is the right of the patient to avail treatment, and right to access to mental health establishment is the responsibility of government. So they have to be given access, and it has to be given at the closest to his community also. It is a huge right that is being bestowed upon the client, and government has huge responsibility here. Unless we're able to say that he's malingering, he does not have a mental illness anymore, we cannot discharge him forcefully also. This is going to be the scenario in public mental institutions.
What happened is we have a BSKY scheme where the government pays for the patients. So now this patient did not get discharged for the next 3 months around. He stayed, I told I'm not feeling like this. He learned all the psychiatric symptoms and we could do nothing about the discharge.
Yeah.
That-
So in case there's a problem, we can complain to board and board can take decisions because board can intervene in these sort of scenarios.
we don't have
If
a board.
if it's wasting the resources of the country, I'm really looking at this as a major problem because it has become his right now. It's going to happen in all institutions.
Okay, about capacity assessment, Arun wants to ask capacity assessment tool. What is the psychometric property of the tool, culturally evaluated, and actually how to do that?
I'm actually not aware. All that I know is a lot of homework happened before the questionnaire was framed, and they made it sure that no psychiatrist or mental health professional spend more than 5 to 6 minutes to complete this questionnaire of capacity assessment. And the first question is very easy, obvious lack of capacity. If something is beyond that, then only you have to do the internal construct validity and reliability, all those things. I don't think is field tested, sir. It's an authorized gazetted document that we have to use. I think we have to do field test and actually report this in publications.
Okay,
Inter-rater
Nimhans-
reliability is also an important thing.
Nimhans has brought in a capacity assessment tool, and they have this, and maybe they have tested it and they talk about it.
What we have a lot of data on MacArthur's instrument that has been used, ma'am, but on our tool that the government has published, I have not read anything that talks about the reliability of the field trials. I think we must do it from IPS to have a field trial and look at how effectively it captures capacity.
Yeah, if we want to challenge that.
I think we should accept it, ma'am. It's a very easy tool, ma'am.
Exactly. That's what. So why should we need to challenge it?
Yeah, it is something like ideas. It's as simple as that, ma'am.
That's what it should be. We shouldn't worry about about the psychometric properties of this scale.
In fact,
Okay.
MacArthur's is very long. It takes at least 4 times the time that we need for our.
Can admission under section 94 extend beyond 72 hours?
No, section 94 is only for evaluation and assessment, observation. It is not to be confused with admission. You cannot admit somebody under 94. It is 86, 89, and 90 only.
94 also emergency treatment, isn't it?
It's not admission process, ma'am. It's only observation. They can be in a short stay ward, ma'am.
Short stay ward, emergency of any, it's not necessarily mental health care establishment,
Yes.
it's a general health care establishment.
Yes.
So also includes treatment, that means stabilizing the patient and then till you find a place, mental health establishment, and put him in the regular health establishment.
Yes, ma'am.
Due process of admission. Yeah.
If a family member comes with a prior prescription, be it yours or your, some other colleagues, and does not bring the patient and requires for a refill of the medicine, can we give? We cannot give.
I think we should use telemedicine services here, call up the patient, talk to him, do some initial evaluation. Unless we have a diagnosis, we should not prescribe is what I think. And by doing telepsychiatric services, I think we'll also establish consent, we'll establish diagnosis. It's safe to prescribe after you evaluate it in some way.
If it has been evaluated by somebody and or we have evaluated before, and the patient's guardians come with a prescription asking for a refill of the medications, should we or can we or shouldn't we give a refill?
If you have prior authorization to dispense from the patient and he's authorized it, we should dispense. We should have some form of documentation to say that the patient is consenting for dispensing process.
Even if the patient is aggressive or whatever the family members tell, we should not give anything.
Yes, that's what the law says. On proxy, the law is silent and we cannot issue on proxy, right? We don't have consent. The whole criteria for the Mental Health Care Act is about consenting. If there's no consent, we have no business. So we'll have to ensure that there's some form of consenting that's happened.
Also, I think you have to make sure that there is a patient, number one, there is somebody, and then what is the condition of the person for whom the prescription is being sought. So there can be kind of a malpractice and misuse of a prescription for somebody. If we see without bringing the patient in, you haven't seen the patient and a relative comes and you fill in the prescription for the first time. If you have seen the patient, that means a person, such and such person exists with such and such illness and condition, then the refill can be done. Without seeing a patient, even if it is by some other psychiatrist, it should not be done for the sake of your safety.
If my pharmacist dispenses a medication and honors a prescription, the penalty for honoring an invalid prescription is much less than what I would have, ma'am. So the pharmacist can actually dispense invalid prescription also. He has less problems.
And they get online also nowadays. It's easy to get.
Yeah.
He's in less of a trouble. Okay, Roop sir wants to ask any complaints against MHCs by patients or their relatives? And I think you told that data regarding ratio of independent versus supported admissions in private and public sector, and how many cases have been rejected by MHRB who were admitted as supported admissions? Any?
In our state, what's happening is the review board is only collecting data. He's saying it's your duty to give the data, so you give the data. What I'm going to do with the data is my business. This is what he's categorically told us, and he's taking data. They've actually not started supervising or coming and overviewing our admission process. I think once it goes into 90, there is a mandate that he has to approve or reject our admission. So I think I have to test my waters for section 90. 89, I only have intimated, he has not got back to me. I have no communication at all. So in the other mental health establishment also, it's the same scenario. He's only collecting data.
89, it is only optional, sir. It's only
What's
optional.
that?
He need not come. 89, it is only optional. He need not come and see the patient or review the admission. If necessary, he can come, or if he thinks he need not come. So 90 only, he has to come. So if
Yes,
we
sir.
are not going to intimate 90, then it is his liberty to remain at his office.
Yes, sir. Sir, what's happening is
not-
I was trying to read the fine lines and looking at 89, what is his obligation? He has no obligation under 89 unless a patient, a family member or an NGO complains, and he has to respond within 1 week for approving or disallowing the admission, sir. Only if there's a complaint. So routine information is what we have to provide, and he has no obligation to intervene there, sir.
Okay. Pankaj says that suppose there is a psychosis patient and he's able to mostly justify his behavior in the clinic. Whenever he is at home, he becomes violent. So now how to bring him and admit him?
So I also gave you the scenario of mobilizing a patient from the community, how your team can visit and how the family can take help from the police and the magistrate. That's one thing about mobilizing a patient. Even if the patient is not behaved violently in front of us, we need a documentation to say that has recently threatened, is threatening, or has actually done something of harm to other people is what we need to document. That's enough to intervene. Section 94 can be used, and you can send a team home to evaluate, do assessment initially, and also mobilize this patient into the mental health establishment. Police can help us also.
So in the absence of AD, who will be the nominated representative? As mostly patients do not have advance directive.
See, in the prescribed law, I think the order of priority will be the parents, the siblings, then the spouse. In that order, they would have given who are the legally authorized representatives. So all those people become legally authorized representative. If he himself has documented to say that who has to be the one, I think that will become the gold standard for us to follow. Otherwise, any family member, any caregiver associated with the person will become a legally authorized representative for us to consent.
There was an interesting question in the case where a father was brought by the son and the wife, admitted in a hospital. And one day after that, the daughter and the son-in-law filed a case of kidnapping.
Mm-hmm.
And that the hospital people, we have kidnapped and we have kept it there. The police came for investigation. Now, who has the first right? Is it the mother and the son or the daughter and the son-in-law?
The blood relatives have more rights than the.
But the daughter versus wife and son, who will have?
I think
bigger
parents
rights.
in the order it becomes parents.
Parents are not there. Parents are not there. The husband, wife, one son, one daughter. Husband is admitted. Wife and son brought the patient for admission. The daughter filed a case of abduction, kidnapping, and investigation. Police came to our hospital. They tweeted, they did a lot of things. But so whom should we listen to save our skin?
I think whenever in doubt, mental health review board should intervene is what I would say.
No mental health.
I think also where the patient has been living, with whom has the patient been living? If he has been living with wife and son, then they
Yes.
will have the first right. If he has been living, the caretaker, main caretaker has been the daughter and son-in-law, then they will have the right. That is there. But one would think, logically, it should be the wife number one, and then thereafter children, son and daughter will come later.
Yeah, so somebody who's associated at least for a period of 2 years is what the research protocol would define, ma'am. If somebody is associated with the caregiving for at least 2 years, he could authorize, caregiver associated at least for 2 years. That was a research protocol requirement. Something like that should be there is what I think, ma'am.
Yeah.
There is an interesting comment by Sanjay Kumawa, sir. Remember to see the patient first medico-legally, then medically, then technically, and then comes empathy. So,
हम लोग उल्टा में देखते हैं.
Yeah, we all been trained to look at that way, but I think we have to do action that is legally correct and forget moral obligation, ethical obligations, and all the other things that's been taught in medical school. I think that would be legally correct.
Don't try to be a god and a savior. First, save your skin. What about the addiction centers where psychiatrist is being used as a rubber stamp?
I think it's a huge problem because there are penalty clauses for serving in establishment that's actually not registered. The moment you're admitting, all admissions are under your name. There's an obligation that we have to see them every day. There has to be documentation that we have to see them. You need at least 2 people for actually authorizing and making admission process under the 89 and 90 process and things like that. So you have a huge manpower requirement. Unless the center has all this sort of requirement, we must not offer our names. Being a rubber stamp is actually getting into a lot of trouble. In Karnataka, there's one death in a de-addiction center where a psychiatrist offered name. Right now, the patient had died and there's a complaint, a lot of media and who was happening. So there's a case registered against the owner and treating doctor also now.
I think this may be talking about de-addiction center, not under the MHCA or under the Ministry of Social Justice. De-addiction center.
Ma'am, now all de-addiction centers.
Earlier de-addiction centers are all under Ministry of Social Justice Empowerment, and they are being run by
a lot of NGOs.
NGOs or even ex-addicts and so on. And that is where the psychiatrists work as rubber stamp. They have no role because there is no treatment that is carried on. It's only dispensing buprenorphine and things of that kind. And that's a huge difficulty that we are facing.
MHCA will have an overriding effect and all de-addiction centers will come under MHCA, ma'am.
But they have not yet been registered under MHCA. So the question about the psychiatrist lending his name to a de-addiction center only for rubber stamp is calling for trouble and is very, very dangerous.
Yes, ma'am. And the typical example here is he has a case registered for negligence now.
Yeah.
How do you discharge a dead body? Suppose a person dies, and then what is the procedure in an MHE?
There's no prescribed regulations in MHCA, but the usual process is if the patient is not going out of the system alive, there cannot be a discharge process. in the discharge summary, it has to be death on at the end of the thing. At the end of the process, we'll have to say patients admitted and issue a separate format. It cannot be a discharge summary format.
And post-mortem is compulsory?
Only if you're not sure about the cause of death, right? So if somebody is a young person, you don't know the cause of death, and you're not a treating doctor, you have to authorize an autopsy. For example, you're treating somebody who has alcohol-related complications. He has multiple medical issues that would explain his death. And if you're comfortable to certify death, I think it's still okay. You don't need autopsy.
But MHCA doesn't talk about death, isn't it?
No, it's not under MHCA at all, ma'am.
It doesn't. So if in a mental health establishment, if a patient dies.
Yes, ma'am. If there's natural cause for death, for example, if he's died of septicemia, if he's died of an MI that you can explain and things like that, there's no need of autopsies, ma'am.
Yeah.
Yeah. Too
See,
many.
basically, the
Please, sir.
antecedents of the case, medically speaking, if you have the papers, etc., the antecedent medical illnesses and the treatment going on, at the same time, you have admitted the patient with the due risk and explained to the caregivers also. In such a scenario, you are aware of the medical background of that person, you can certify the person. However, if it is not known, it is not certain, it becomes an unnatural death, or to know the cause of it, definitely you can ask for an postmortem in such a scenario.
Okay.
To ascertain the cause of the death. And of course, if it is unnatural, then definitely for sudden death or for any kind of unusual incidents, you can report it for postmortem.
Sure,
What
sir.
about absconding? Somebody absconds.
Yeah.
The law says about it, I think, about you need to lodge an FIR, inform the police, the caregivers about the same, and then they immediately, the police it will be responsibility of them to find out the patient, the caregiver. If the patient is found at home, then accordingly they will report to the mental health establishment, and if necessary can bring back the patient.
If it's a voluntary admission and patient absconds,
Only in case of prisoner.
then we
or-
discharge.
No, only 103 section which talks about prisoners and people who are on trial. We have an obligation to inform police. Otherwise, it's silent on 86, 87, 89, 90 admissions. So if he absconds, we have to document to say that he has left the hospital premises without completing discharge formalities. It's a good practice.
We have two people who have raised their hands. Sir, continue. Sir.
Yeah, suppose someone wants a discharge in the middle of the night, question by Sheikh Idris, and the consultant is not available, discharge card is not ready, and on top, he has not cleared the hospital bill. So what to do now?
Now, what happens is you can prescribe your rules and regulations to the hospital and say that discharge will happen in the morning hours between 9 to 12 p.m. Unless and until there's an emergency thing is what we can certify. We can actually make our own SOPs for discharge, and patient who gets admitted has to sign up for these sort of protocols. And in case somebody is not paid up the bills, you cannot do anything. We'll have to move a civil suit, hire a lawyer paying 3 times his balance money and put a petition and actually try to recover. It's a civil suit.
And
Police
in any case, it's 24 hours after request is made. You have 24 hours after request.
Within 24 hours.
Within 24 hours. So you have time. There is
Ma'am,
no
if we can retain him only if you have reasons to believe that he has some dangerousness criteria, ma'am. Otherwise, he can discharge himself and leave the premises without completing format.
That is fine. But then what I'm saying is that if somebody makes a request for discharge, so you have within 24 hours, you can discharge. It's not that immediately, whatever you are doing, you have to immediately rush to discharge him.
Yes, ma'am.
We have 2 raised hands. Mrs. Veena was there. Is she there?
Not now. I think Roop sir is there. He wants to say something.
Can I, most of the time the discharge, when the patients want to get discharged, the most common excuse is there is a death in the family or somebody is serious and they want to go immediately. And whatever is the condition of the patient, and whether it is day or night, you have to abide by that emergency, whether it is true or it is a fake. It's a most common excuse for taking discharge, whether the patient was admitted as a supported admission or independent. That's usual practice. And secondly, in patients who abscond, the responsibility of the owner of the hospitals is to a great extent. Whether the attendant family member was there or not there, both ways, they are after the owner. the
Sir,
family member.
I must admit here, I've been into multiple situations where they really made me feel guilty for a patient leaving the hospital and escaping, and actually tormented me, troubled me in a lot of ways, sir. But with the new act, I've been able to use the provision and say that patient can leave, and I'm not here to hold him back. I have no authority to hold him back. The law says that he can leave himself, and he's exactly done what it's been specified in the law, and I have no obligations, is what I tell them, sir. I show them the provision and say that this is what the law prescribes and I have no obligation. I cannot keep him here. He can complain against me if I keep him against his wish. That is his power. I have no force that I can use to retain him, is what I tell them, sir.
This is only in case of voluntary admission. What about high support admission?
High support also, if you look at the act, sir, it's very silent about it. It's not talked about it. We don't have any obligations, what it says. They're not prisoners. They're not somebody who has to be treated in a way that you need physical restraint. I believe that the hospital has to be a least restrictive care environment. And I'm going with the spirit of the law here. We cannot restrict the movement of the patient to that extent and actually hold them and tie them back and restrict them, sir. It's okay. Like, if one or two patients leave, we must accept, sir. I tell them during admission also that we have security and we do all those things, but the escapes are possible in jails. Escapes is possible in any hospital. In our hospital also, there's any chance that they can escape. I can only have a CCTV system to review and tell you what happened.
Sir,
Yeah. Can I speak?
Yeah, please.
Yes.
Yeah,
yes, ma'am.
I think
Yes,
wonderful presentation by Dr. Goda and everybody, I think all learned, intelligent experts here. This is about a particular case. The person is diagnosed with bipolar, and so his different visits and different rehabs have been not so good. They have been physical as well. And he has developed a scare for a rehabilitation center. And now in Hebhas for 2.5 months, almost ready for discharge, but seriously nowhere to go. And really don't know how to proceed. Almost helpless. So what is it that we can do? Because if we just leave him, and there have been cases where he will just miss his medicines and no activity and little bit of extra smoke, overspending, money is an issue, definitely. So what is it that we can do?
Ma'am, I don't think we have any solution as of now, ma'am, because the obligation cast upon the government by the law is a humongous thing. They have to set up a lot of infrastructure to move patients who don't require the stay at mental establishment, and they must live in community centers, ma'am. Till that is established, I don't think we have options at all, ma'am. We don't have to feel guilty for this current scenario. It's an obligation of the government here, ma'am.
Thank you, Mahesh. Amrit, I think we have to wind up now. There are still 125 participants, but we have overshot already. Mahesh has been talking with us.
in spite of you talking so much, 135, 945, it's a big thing. Speaks a lot about Mahesh, Savita Madam, Kumar sir, and Viraj. Tufan sir.
Yes.
I think one thing last, if I may be permitted to say, is that, we as physicians, we are used to admitting patients on advice, medical advice. Like we, the doctors, psychiatrists, and physicians, we say, admit the patient. Whereas MHCA, it doesn't say that the doctors are advising admission. It's the family seeking that admit me, admit my ward, admit my, dependent, or and so on. So this is the kind of a reverse process, and which seems a little unusual for us. Although, I mean, their request is to be supported by two certificates from the psychiatrist or a mental health professional that the need for admission, but usually it's the other way around, that nobody makes a request for admission, even voluntary admission. Why should this be so? I mean, in Mental Health Care Act, why should a person who's in need of care should make a request for voluntary admission on a form, fill up a form? You know, things like that. I mean, this is very, very discriminatory and very, very stigmatizing, I would say. And we need to really take a look at it and see also, you know, the right of it's not the right, the usual practice that we follow in medicine is that the doctor advises admission and not the person seeking admission. Ki mujhe dakhil kar lo. I think just that this one comment I wanted to make it the last thing. Thank you very much.
Thank you, ma'am. Malapan sir, any comments from you?
It is a very ideal law in an ideal society, but that is highly impracticable in India, I would say. Unless the government comes with a lot of money and lot of implementation, we will not be able to follow it in letter and spirit in India. That is a ground reality. But as Dr. Magesh has told, we have to make efforts to fulfill the requirements of the law from our point of view. It may not be a complete one. We will safeguard ourselves by following it as far as possible, but beyond which it becomes a lacunae of the state and lacunae of the MHRBs to do its duty. So we need not bother much about the deficiencies in the government. We see that we follow some minimum or as far as possible what all can be done by us in our documents. That will save us in the courts, that will save us in the future. That's all we can do it now. That is a pragmatic way of approaching the Mental Health Care Act 2017 now. And we cannot keep on blaming the government for not implementing it. So it may take another decade or so to implement it fully. So as far as today, we will do whatever possible for us to do and safeguard ourselves. That will be my comments as a last comment. Thank you. Thank you for your opportunity.
Apt summary, sir. Apt summary. Thank you. Kumar sir, any words from you?
Well, nothing much to say. Nice presentation by Dr. Mahesh. As rightly said by our chairperson, Dr. Malapan, that we need to do the follow the protocols and guidelines. It will safeguard us from legal battle or any kind of calamity that may arise. As I understand, mental health establishment, whether it is a private or public, they are silent volcanoes. We don't know when they will burst or when the tragedies will happen. And if it happens, you won't have any end to the tragedies or the challenges you will face. So better be safe and cautious right from the word go. That's it. Thank you.
Thank you, sir. Tufan sir.
Thank you, Mahesh, for your brilliant presentation and a lot of questions still are unanswered. And you have been speaking so long. Let us reserve it for another time. But a simple case dignity. A person with mental illness is admitted for a severe physical danger to a nursing home. When he is admitted, he does not disclose I am mentally ill, or he does not have sufficient symptoms to, or they are masked by the physical illness. And his medicine is discontinued, he goes into exacerbation. What will they do? They are not registered under mental health care act. They need not be. And the treating that patient may require more than 10 days. Where do you place the patient? And this is not a irregular, this is a regular, this is a common case pregnancy. Am I audible?
No.
So in similar cases, the act is silent. You have to reform the act. The initiative by Dr. Savita Malhotra may yield some result. The survey which you have completed, and that will show where we stand. And in addition to being protective about ourselves, we have to know where we stand, because basic purpose of the act is to serve the patient. We should not fall short of that also. Thank you. Thank you, Mahesh, for your brilliant presentation.
Thank you, sir. Thank you, Alim. Thank you, Amrit. Thank you, Chairperson.
Thank you all. Thank you all, and good night to everyone.
Thank you. Thank you
Amrit,
very much.
please thank all of.
Chalo, thank you so much, Mahesh boss, Malapan sir, Savita madam, Sanjay Kumawat sir, Tufan sir. I think these are the five. If you look at 7 to 10 top people in the mental health act, 5 people were present here today. And if you look at the lowest 10, I and Alim were present here. So we cover the entire spectrum of the things, and we had more than 300 people who had logged in today. Peak of 240 on an often repeated topic, as Mahesh was telling. That's a huge number, Mahesh. The number of webinars that are coming on MHCA, the number we had 240 people, the peak, and more than 300 logins. So that's good. Thank you so much for covering everything. And you covered a lot of things. You spoke a lot of things very fast. Things that needed to be told rapidly. You talked rapidly. It was not that you spoke for 40 minutes. You spoke for an hour and 40 minutes. That was the best thing I saw. Where it needed to be told elaborately, you did that. And we had superb, inputs from Savita Madam, Sanjay sir, Malapan sir, and at the end, Tufan sir. So thank you so much for coming, joining us, and enlightening us. We'll be again calling you, Mahesh. Be ready in another 3 months, 2 months. We'll have a corollary to this.
And Shaman, please announce about our special episode on schizophrenia and the eve of Schizophrenia Foundation Day.
Yeah.
Shaman has few announced. Yes.
Yes, sir. Yes, sir. Professor Norman Sartorius will be with us on 25th of May. So we'll be collecting a few questions that we can put to him. So we invite all of you for this special episode. It is just on the next day of World Schizophrenia Day. So we'll be with Dr. Sartorius that day.
Welcome everyone. I request everyone to also, we'll be sending flyers this time a little early. Please spread it out.
Thank you so much again. It's a pleasure having you on our musings. Thank you from the team and the entire IPS State Secretary and the President of it, and as well as Torin for supporting us unfailingly. Thank you so much. Good night.
Thank you.
you.
Thank you, Amrit.
Thank you. Good night.
Thank you, Alim. Bye-bye. Good night.
Thank you,
ma'am.
Mahesh. Thank you.
Thank you. Sir, ending the meeting now.
Yes, let us send.